Yes, Mr. White.
Thank you, my Lord. My Lord, before lunch, we had some exchange about the impact on the existence of a reasonable expectation of privacy of the effect on the claimant, and my Lord drew attention to the pleaded case about impact. But my Lord, impact on or effect on the claimant is only one of the factors taken into account in Murray when considering reasonable question of privacy. And in our submission, focusing on that alone, without looking, for example, at the nature of the activities, risks making any information which has harmful impacts private. And that wouldn't be an appropriate development of Article 8. So although impact is important, and I'm going to come on to impact in relation to the third criterion, that doesn't mean in our respectful submission that the nature of the activities, the first criterion I've been addressing, isn't also important. My Lord, the second criterion which was identified by Mr. Justice Warby was the status of the individual, and in many cases the first and second criteria, nature of activities and status, may be bound up together. They were in Yo and they were in Axon, but in other cases, and we suggest JR 38 is an example, activities without status may be important. In that case, the boy was an ordinary member of the public. He had no public status of the sort that either Mr. Yo or Commander Axon had. We submit that the Court of Appeal's general rule effectively puts status of the individual to one side in the paragraph I showed you this morning. We suggest that's wrong, and it's a clearly relevant factor, and indeed is the first factor identified in the Murray list. And one sees it at play in some of the cases we cite in our printed case, for example, the well-known case of Lord Brown, where the Court of Appeal regarded as highly significant the fact he was the chief executive officer of the company, and in conjunction with the information being about the use of corporate information and resources. So that's another example of the binding together of status and nature of activities. And my Lord, I just wanted to add in relation to this second criterion, the point we make in our case about the Strasbourg Court recognizing and to some extent running together notions which relate to the activities of politicians with notions relating to the activities of businessmen or women involved in the management of public companies. And one sees that in particular in Al Fayed and the UK. My Lord, that's the relevant passages at 1619. Paragraph 75. This isn't an Article 8 case, as my learned friends correctly point out. It's an Article 6 case, but nevertheless the observation about businessmen and women involved in the management of public companies is pertinent in our submission and supports Mr. Justice Warby's second criterion in Yo. In particular, we draw attention to the fact that the Strasbourg Court in this authority found on a case about a politician, Oberschlick and Austria. You see that in the footnote to paragraph 75. My Lords, the reasons for regarding there as being a public interest in the activities of public companies appear from paragraph 69 of the judgment at page 1617, and in our submission are compelling. And what we suggest is important for this second criterion is the drawing together with politicians of persons like the respondent in the present case who are responsible for managing public companies. So status is significant. That observation in the Strasbourg court in Al-Fayed was repeated in Steele and Morris at paragraph 94. That's page 1658.
Paragraph? Which paragraph, please, Mr. White?
94 of Steele and Morris, my lord.
I'm just trying to understand the Fayed case. Was that about the inability to sue the Companies Act inspector for defamation? Sorry, I'm just...
Yes, that's right. And that was why it was an Article 6 case. But the notions under discussion at paragraph 75 support the significance of the status criterion that Mr. Justice Warby identified. Steele and Morris was, again, the context is different. It was a case about a defamation claim brought by McDonald's against two animal rights protesters, and the observation at paragraph 94 is concerned with the reputation of public companies, and I cite it only because it repeats the point about the limited privacy rights of those involved in the management of public companies. Lord, our submission, and there's a tension with a point my Lord Sales put to me before lunch. Our submission is that where the business activities of a person like the respondent who's involved in running a public company are alleged to be unlawful, the considerations identified in Al-Fayed apply a fortiori. Lord, we do draw attention in our printed case to the traditional position in breach of confidence, where the public interest doesn't depend upon showing that allegations of misconduct are proven. The old iniquity rule in breach of confidence doesn't require the allegations to be proven, only that there have been sufficient inquiries made by the publisher about the truth of them. My Lord, that takes me to the third criterion identified by Mr. Justice Warby. I should, for the sake of good order, repeat the submission that the second criterion is again inconsistent with a general rule which excludes that from materiality. The third criterion is to do with the seriousness of the attack on reputation. And in our submission, the cases show that Article 8 only comes into play, to use the Strasbourg formula, where the attack on reputation constitutes such a serious interference with private life as to undermine personal integrity. Not all attacks on reputation cross what the Strasbourg court calls the threshold of severity. And my Lord, this emerged particularly clearly in Caraco and Hungary, and in paragraphs 22 to 23 of that judgment, at pages 1669 to 70. Caraco is a case where a flyer signed by one politician criticized another politician. The criticized politician brought criminal proceedings for damage to reputation, and those criminal proceedings were dismissed, and it was held there was no violation of Article 8. But the discussion at paragraphs 22 to 23 of the different ways in which reputation is protected in the systems of law of the member states is illuminating in our submission. The question they're considering is whether the notion of private life should be extended to include reputation, and the court notes the reference to personal integrity in the von Hanover judgment reflects a clear distinction, ubiquitous in the private and constitutional law of several member states, between personal integrity and reputation, the two being protected in different legal ways. In the legislation of several member states, reputation has traditionally been protected by the law of defamation as a matter related primarily to financial interests or social status. For the court, personal integrity rights falling within the ambit of Article 8 are unrelated to the external evaluation of the individual, whereas in matters of reputation, that evaluation is decisive. One may lose the esteem of society, perhaps rightly so, but not one's integrity, which remains inalienable. And then there are two concepts or notions, both linked to the seriousness of the effect on private life of a particular defamatory attack. The way it's put firstly is in the court's case law, reputation has only been deemed to be an independent right sporadically, mostly when the factual allegations were of such a seriously offensive nature that their publication had an inevitable direct effect on the applicant's private life. However, in the instant case, the applicant's not shown that the publication in question, allegedly affecting his reputation, constituted such a serious interference with his private life as to undermine his personal integrity. The court therefore concludes it was the applicant's reputation alone which was at stake in the context of an expression made to his alleged detriment. And my lord, that focusing on impact or effect was recognised in the discussion of Caraco in the Re Guardian News and Media case in this court at pages 37 to 42. That's paragraphs 37 to 42, electronic pages 1146 to 1147.
And Caraco was criticism of a member of Parliament for having voted in Parliament in ways which were not in the best interests of the county he represented, I think.
That's right.
That's the gist of it, yeah.
So my first and second criterions didn't feature in the reasoning, but the third, which is the impact, did.
And his complaint to Strasbourg was that criminal libel proceedings had been dismissed by the courts of Hungary.
That's right,
yeah.
and that was a violation of his Article 8 right.
Yeah.
But, my lord, the discussion of Caraco at pages 1146 to 7 in Re Guardian Media recognises that was a distinction drawn in Caraco based on the seriousness of the interference with private life. It's worth remembering that there were 4 applicants in the Re Guardian Media case. One of them had, if I may use the expression, outed himself by bringing proceedings in his own name, and it was held that he couldn't have a reasonable expectation of privacy. 2 of the remaining 3 had left their addresses and were no longer in contact with their solicitors, and it was said that in those circumstances there could be no suggestion of a sufficiently serious impact on their relationships in the community for them to have an engaged Article 8 right. That left the 4th, anonymised as M, who had put in some evidence about impact on his relationships within the community. But my lord sees at paragraph 40 and returning to it at 42, the expression or the explanation of Caraco as being a case where the applicant hadn't shown the attack on his reputation had so seriously interfered with his private life as to undermine his personal integrity. And that's contrasted with the evidence in M's case, where there was some evidence of impact on his relationships within the community.
Yes. But it wasn't analysed in Guardian as a case where Article 8 wasn't, well, there was no claim under Article 8 at all.
No, but that's why I drew attention to the different positions the 4 men found themselves in. Yeah. It was only in M's case where there was evidence of impact on his relationships in the community that Article 8 was engaged. So merely because it was damaging of the other 3 didn't engage Article 8.
But is that not the opposite of what is said in Guardian? Having explained what was said in Caraco in paragraph 40, I presume this is Lord Roger,
it is.
Says the contrary to counsel's submission, however, this conclusion did not mean the court was proceeding on the basis that the applicant's claim in respect of his reputation did not fall within the scope of Article 8. That would have been inconsistent with the court's previous case law and would have made nonsense of the reasoning.
Well, the point that I understand Portimon to be making is, although reputation can be protected by Article 8, his claim, Mr. Caraco's, was unsustainable. A claim to protection of Article 8 on the facts of Caraco, because it didn't cross that threshold of severity.
No. We'll have to read it in our own time, but that, at any rate, doesn't seem to be what Lord Roger is saying. It looks as though he's saying that this is a case which did fall. Caraco fell within the scope of Article 8. On the basis only of loss of reputation, not on the basis of damage to personal integrity, and that in that situation you had to balance Article 8 and Article 10, and the conclusion was that there was no violation of Article 8.
But doesn't, with trepidation, the sentence beginning putting the two strands together,
Yep.
The court goes on to find in paragraph 28 the applicant's claim that his reputation as a politician has been harmed is not sustainable under Article 8.
Yes, but it didn't succeed. I think that's what's meant.
Yes. So I'm accepting in this submission that an attack on reputation can be within the scope of Article 8, but in order for Article 8 to come into play and provide protection, it has to cross the threshold of severity. And that threshold of severity is articulated again in paragraph 42 by reference to the evidence in M's case alone. Lord, in our submission, it becomes clearer in the Grand Chamber decision in Denisov, which is in paragraphs 110 to 114, which are at pages 1740 to 41. There's a discussion of how this threshold of severity fits in to Article 8. Do you see at 1740 in paragraph 110, as in the course of discussing the way in which Article 8 may be engaged by the reasons behind a measure or the consequences of a measure, the court is discussing the impact or effect line of authority at 110 and following. They say, in cases where the court employs the consequence-based approach, the analysis of the seriousness of the impugned measure's effects occupies an important place. And then a number of examples of that are given. 111 identifies the situation we're discussing. 112 identifies the situation we're discussing. In addition, the court's ruled that an attack on a person's reputation must attain a certain level of seriousness and be made in a manner causing prejudice to personal enjoyment of the right to respect for private life. That's a reference to a similar formulation to the Caraco one, only in Axel Springer. And then say this requirement covers social reputation in general as well as professional reputation in particular. And then could I invite you to drop down, cast an eye down 113, but drop down to 114. The term threshold of severity I've used a couple of times comes from 113, but at 114 the court says, it's thus an intrinsic feature of the consequences-based approach within Article 8 that convincing evidence showing that the threshold of severity was attained has to be submitted by the applicant. As the Grand Chamber's held, applicants are obliged to identify and explain the concrete repercussions on their private life and the nature and extent of their suffering, and to substantiate such allegations in a proper way. Now, my Lord, that's an important evidential point about the extent of the severity which this third criterion requires. And if you drop back to Yo and see how it played out in Mr. Justice Warby's judgment at 144 to 5 and 147, which is 1376 to 7. At 145 on page 1377, Mr. Justice Warby was discussing this criterion, the threshold of severity. And he says, about halfway through, well, I'll pick it up at the beginning of 145. The distinction is slightly elusive from the perspective of a common lawyer, but it does seem clear that a defamatory attack wouldn't be considered as undermining personal integrity in the sense that phrase is used in this context, merely because it was a substantial assault on a person's honesty. The word personal integrity in this context appears to have connotations of wholeness. A defamatory attack cannot appear as undermine personal integrity if it has an inevitable direct effect on private life, which is quite severe, such as ostracization from a section of society. So that's an example of the level of severity required. And at 147, it's noteworthy that he says, I have no doubt Mr. Yeo suffered considerable distress and anxiety as a result of publication. There was, on the evidence, no interference of any seriousness with his family or home life or with his relationships within his community. So he's looking at the sort of evidence required, as they do in Denisov, to cross the threshold of severity. And drawing those threads together, we submit that this third criterion is inconsistent with a general rule based on generalized concerns about impact on reputation. The Court of Appeal's general rule doesn't require evidence of the seriousness of the effect on the individual of a particular disclosure. It proceeds on presumed impact, and in our submission, that significantly undermines the soundness of that general rule. I made the point this morning that it's, in our submission, self-evident that not all information about any criminal investigation will amount to such a serious attack on a person's reputation as to cross that threshold of severity. And I used the example of someone under investigation for offences of protesting, and there may be other and better examples. But, my Lord, the documents before the court recognise that the effect on reputation will depend on the nature of the offences under investigation. Can I just give you two references? At page 2944, the electronic bundle, there's a passage, paragraph 64, of a judgment of Her Honour Judge Taylor in a case called Crook and Chief Constable of Essex, which my learned friends rely on, where she says that there is a difference between, for example, sexual offences and what she calls acquisitive offences under the Theft Act in terms of public reaction to the fact that there is an accusation or an investigation. Second example is at page 4661 in the Home Affairs Committee report on which my learned friends rely, where the committee says that sexual offences are within an entirely different order to most other crimes, carrying a particular and very damaging stigma. That's page 4661. And in our submission, the Court of Appeal's general rule, which treats any information about any police investigation as carrying a reasonable expectation of privacy because of the damage done to reputation, is not consistent with this third criterion. But I go further, and I submit that the respondent's evidence in the present case didn't establish that the threshold of severity was attained. It didn't identify, to use the Denisov language, identify and explain concrete repercussions on his private life or the nature and extent of his suffering. Lord, his witness statement is at page 457 to 9. And it's in very general terms. The paragraph 1, the conduct's caused me substantial distress, stress and anxiety, and then 2 passages in the confidential schedule at page 457 and 459, paragraphs 19, 20 and 26, are very generalized allegations about distress, outrage, anxiety. Well, they don't go above what in Yo, Mr. Justice Warby held was insufficient to cross the threshold of severity. His only other evidence on this topic was a witness statement from his wife, which is at page 461. Paragraph 1 at 461 contains again a rather general reference to substantial distress and anxiety. And paragraphs 5 and 7 on pages 464 to 5 talk again about stress and anxiety in very general ways. Nothing really about relationships with the community. And as I said a moment ago, in my submission, comparable to what Mr. Justice Warby in Yo held was insufficient to take the case above the threshold of severity. And my Lord, that third criterion we rely on to both demonstrate the unsoundness of the general rule, but also show why it shouldn't apply in the present case. But we then make a further point, which is this. Even if an attack on reputation does reach the threshold of severity in a given case, so that Article 8, to use the Strasbourg Court's language, comes into play, this doesn't mean it has to be protected by the tort of misuse of private information rather than the tort of defamation. It's left to member states to put in place adequate laws protecting Article 8, and the main way in which English law protects the reputation facet of Article 8 is through defamation. And Lord, I'm going to come back to that in a minute, dealing with inconsistencies between where the Court of Appeal have left the law and the established law of defamation. But before I do that, I need to deal with what in our submission is an artificial distinction drawn by the judge and upheld by the Court of Appeal between the activity under investigation and the UKLEB's assessment or suspicions in relation to that activity. That distinction is drawn in 2 places by Mr. Justice Nicklin. In the latter place, which is paragraph 125 1b on page 368, that's the public judgment reference. The reference is particularly important because of his recognition that, just get the wording, under the heading nature of the activity in which the claimant was engaged, that the activity the UKLEB was investigating was whether the claimant had been involved in corruption in relation to X Limited's activities in the foreign country. Framed like that, there might be a strong argument that this wasn't something that would give rise to a legitimate expectation of privacy. But that's not the correct approach. Claimant's not by these proceedings seeking to assert a privacy right over this alleged conduct. Mr. Owen repeatedly disavowed such a claim. Claimant, he submitted, is not arguing the defendant could not report itself on the matters the UKLEB were investigating. Claimant's reasonable expectation of privacy was over confidential details of the UKLEB investigation, in particular the UKLEB's conclusions as to the claimant's conduct. Now, my Lord, we submit that that distinction between the underlying conduct under investigation and the UKLEB's assessment stroke suspicions stroke conclusions is unsound. It's unsound, firstly, because it fails to recognise that the information reported in the article, which I know my lords have all read, about the UKLEB's assessment can't be divorced from what that conduct was. The conduct they have assessed is set out, the providing false information to the board. And the way the information with a capital I is formulated, as set out in the judge's private judgment at paragraph 120, which I think is the only place, apart from the pleadings, where the actual information is set out. Well, that's page 305 to 6. Does set out the underlying conduct, not just the UKLEB's assessment or belief. And one can test whether that was the focus of the complaint by reference, as we point out in our printed case, to the pleaded claim in relation to data protection, which was ultimately not pursued, where it was said that information about the alleged commission of an offence by the claimant amounted to his sensitive personal data. Well, that's page 384 in paragraph 8 of the particulars of claim. So that formulation acknowledged correctly in our submission that the information related to the alleged commission of an offence by the claimant, not just to the assessment by the UKLEB. Now, Lord, in the Court of Appeal, Lord Justice Simon acknowledged that information about a criminal investigation into an individual may include information about the alleged criminal conduct. And in our submission, the report in this case clearly did so. And we make this submission that the distinction the judge drew, as well as being factually unsound, is also inconsistent with the approach in the authorities to the nature of the activities. Can I just seek to illustrate that by re JR 38 that we looked at before lunch? In that case, the activity which was said by Lord Toulson not to fall within the protection of Article 8 was not being photographed by the police or having the photograph published in the newspaper. It was the participation, alleged participation, in the riot. But, my Lord, there's a yet still further problem in our submission with this distinction, and it is this. The Court of Appeal upheld the distinction on the basis that the assessment stroke suspicion stroke conclusions of the UKLEB also conveyed that the investigating authority regarded the allegations as serious enough to warrant an investigation and had drawn preliminary conclusions to the disfavour of the claimant. But, my Lord, that rationale for the distinction bumps up hard against the established approach in the law of defamation, as we seek to explain in our printed case. In the law of defamation, it's recognized that an allegation that someone's under investigation is only damaging to reputation because it implies that the person has, by their conduct, brought suspicion upon themselves. And that's why in defamation, it's not a defense to show that an investigator has formed an assessment or suspicion. You can't even plead that. You have to plead facts relating to the claimant's conduct in order to justify publishing information about a criminal investigation. That's the so-called conduct rule. And can I quickly show you the authorities, two brief passages in the authorities on that. The first is at page 2202 in the case of Shah against Standard Chartered Bank. So it's the Court of Appeal in a libel case discussing the judgments of Lord Reed and Lord Devlin in Lewis and the Daily Telegraph, which I showed you this morning. Can I pick it up, please, at 2202, page 261 of the report, in the second full paragraph? He says, that still leaves the important statements of Lord Reed and Lord Devlin in Lewis and the Daily Telegraph. Both these passages seem clearly to suggest that the reason why a plea of reasonable suspicion is sustainable is because its sting is that the plaintiff has, by his conduct, brought suspicion upon himself. For these reasons, I consider Mr. Brown's submissions correct, and that it's an essential requisite of a defence of justification of reasonable suspicion that it should focus on some conduct on the plaintiff's part giving rise to reasonable suspicion. So the point is that in the law of defamation, to say that someone is the subject of a criminal investigation is only reputationally damaging because of what it implies about their conduct and not otherwise. Hence the conduct rule in relation to justifying such a statement. But in the courts below in the present case, they've drawn a distinction between what is said to be the reputationally damaging suspicions or assessment and left out of account altogether the underlying conduct. Indeed, Mr. Justice Nicklin goes further in the passage I drew attention to and says that framed as the underlying conduct, it would be unlikely to give rise to a reasonable expectation of privacy. And my Lord, it's an important point because it is central to the treatment of the nature of the activities in the courts below. And one can posit a situation in which Bloomberg had been sued in defamation for publishing the information about the criminal investigation into the claimant. It would be likely to bear the defamatory meaning that there were reasonable grounds to suspect. But Bloomberg could justify that by pointing to the conduct which the claimant concedes was not false, was not falsely portrayed in the article, of him providing false information to the board. Now, my Lord, that takes me more generally to our submission about inconsistencies in the approach of the courts below with the law of defamation, which is an important topic. In Cuja, the majority in this court were concerned about the need to avoid what Lord Sumption spoke of as incoherence between the approach of the law of defamation to a particular fact situation and the approach of the developing tort of misuse of private information. My Lord, we needn't turn it up, but that's in paragraph 34, subparagraph 3 of Cuja, page 1430 to 31. And the point he made was that under the law of defamation, to refer to what had been said in open court about Mr. Cuja would be both privileged and true, and therefore a defamation claim couldn't lie, and that it was incoherent to uphold a claim for misuse of private information based on interference with Article 8 rights, where there was such a clear answer to a claim based in defamation. My Lord, we draw attention in our printed case at paragraph 67 to a similar observation in the judgment of Lord Neuberger, the then president, in a case called O against Rhodes, which is the well-known case in 2016 where this court set the boundaries in the modern law of what we used to call the Wilkinson and Downton tort. And what is said at, I'll give you the reference, it's paragraph 111 of Lord Neuberger's judgment, page 3064 of the electronic bundle. He said that the Wilkinson and Downton tort, and I quote, should not somehow be used to extend or supplement the law of defamation. My Lord, as Mr. Justice Warby explained in a case we'll come to called Sikri and Associated Newspapers, defamation is what he called the mature and natural tort, providing remedies for reputational harm. It's one which contains a carefully established regime for balancing reputation and free speech. And that balance, struck by the common law, has recently been reconsidered and in some important respects recalibrated by Parliament in the Defamation Act 2013. There was no suggestion in that recalibration that pretrial anonymity was somehow desirable to protect reputation in the tort of defamation. The existing rules provide an appropriate framework. Now, my Lord, we identify in the printed case 5 matters of concern about consistency of the judges and the Court of Appeal's approach with the law of defamation. I've already touched on 2 of these. The first is the no smoke without fire rationale for the general rule. We submit that the law of misuse of private information shouldn't be developed on the basis that members of the public would assume the worst and associate investigation with guilt, when the law of defamation proceeds on a different basis. That's the first inconsistency. The second is one I addressed a moment ago, relating to the distinction drawn by the judge and upheld on appeal between the underlying factual allegations about the claimant's conduct, recognized by the judge as not susceptible to a reasonable expectation of privacy, and on the other hand, the UKLEB's assessment, suspicions, conclusions in relation to those allegations, which are. But for the reasons I gave a moment ago, the law of misuse of private information shouldn't base a general rule of the sort emerging from the Court of Appeal on the basis that information about a criminal investigation is reputationally damaging because of the investigator's assessment, suspicions, or conclusions, when in the law of defamation, it's only reputationally damaging because of the implied allegation it carries about the claimant's underlying conduct, hence the so-called conduct rule. But, my Lord, the concerns don't stop there. A general rule, divorced from all the circumstances of the case, that there is a reasonable expectation of privacy in information about a criminal investigation, which is based on harm to reputation, is irreconcilable in our submission with the new requirement which Parliament legislated for in Section 1 of the Defamation Act 2013, that introduced the requirement of serious harm. In other words, in order to be defamatory, the publication of the statement in question must have caused or be likely to cause serious harm to reputation. Well, we probably don't need to turn up Section 1. It's at page 4620. And it was considered by this court in Lachaud. The establishment of serious harm to reputation is a question of evidence about the impact or effect on the claimant, not just the meaning of the words, although the meaning of the words is a relevant factor. My Lord, as we submitted earlier, not every disclosure of the fact of a criminal investigation of whatever kind, into whatever kind of criminal activity will cause serious harm to reputation. Some may, others may not. And I use again my example of a protester, as opposed to, for example, a sexual offender. And we say it's not appropriate for the law of misuse of private information to base liability on presumed harm to reputation in general, when Parliament's recently said that in the mature tort, serious harm must be established. And, my Lord, the fourth concern about consistency with defamation is a fundamental one. Although Mr. Justice Mann awarded damages for injury to reputation in Richard against the BBC, in both the present case and in Sikri against Associated Newspapers, it was held that damages for injury to reputation cannot be awarded in a misuse of private information claim. And the rationale for that, the first rationale for that, is in a misuse of private information claim, the defendant is not able to defend the claim by establishing that the defamatory statement is true. Truth of it may go to a public interest defence, but it is not, unlike defamation, an absolute defence. Mr. Justice Nicklin's reasoning at paragraphs 149 to 152 deals with this both at a level of principle and by reference to the concession made in this case that the facts were not false.
Those references in the closed or the open?
They're in the open, my Lord. I've tried over lunchtime to catch up, and I'm just checking I'd got it right. Yes, so it's electronic page 377 to 9. And my Lord, the whole passage rewards close attention, but the kernel of the reasoning emerges from the second half of paragraph 151 at page 378. After a discussion of terminology, reputation, esteem, and so on, the judge says this: but whatever it's called, in a misuse of private information claim, a person cannot be awarded any element of compensation for harm to, vindication of reputation, caused by the publication of defamatory statements if the defendant's not given the opportunity to defend the statements as true. that would be to award at least some element of damages on a false basis and be contrary to the principles I've set out above. And he then, at 151. At 152, he then makes reference to the concession that truth or falsity didn't arise. But his reasoning culminating in the second half of 151 is wider, and it's tied to the nature of the tort and its structure. Now, my Lord,
I wonder if that may be a bit too broadly expressed. I'm just thinking about a Google Spain situation where there's undoubtedly a breach of Article 8 by publishing something which is true, but nonetheless damages the person's reputation and damages the esteem, social relations, and so forth.
the difficulty with reasoning from Google Spain may be that the passage of time in that case it impacts on the assessment.
Yes, that's why I'm wondering if it's perhaps been a bit too broadly expressed. I mean, because that might be an example of a situation where there is an actionable wrong causing damage to reputation, which damages ought to be recoverable, notwithstanding the fact that the information published was true.
There are other examples, as Professor Moram says in the article that we cite, some types of medical information may be reputationally damaging. Yes. If one has in the past had a particular disease.
Quite.
But those are actionable in misuse of private information because the information is private, not because it's reputationally damaging. It's the critical point that she makes.
Yes, but that's what makes it actionable. But once you're awarding damages, are you not looking to the harm that actually resulted? For example, if you publish information that somebody had in the past been treated for a sexually transmitted disease, then that would be actionable, notwithstanding it was true. And one would have thought one of the purposes of awarding damages would be to compensate for the impact that the publication had upon the person's social relationships and the esteem which the person was held and so forth.
But as Professor Moram says, that's an incidental effect of a claim in privacy based on what is genuinely private information within the sphere of private life. The advice...
Forgive me, I mean, in what sense is it incidental? Didn't it go directly to, I'm sorry to come back to 9 minutes, but the ability to form personal relationships in the course of your private life? If everyone shuns you, why isn't that a very direct interference with your private life in the sense of the ability to form relationships with people?
But people may shun you for things which are not not within the sphere of your private life. Business misconduct, which is what this case is about, is an example.
Right, they may do, but they may shun you for things which are within the sphere of your private life as well.
Absolutely. And it's no part of my case to say that where the information relates to a matter within the sphere of private life, such as medical information, the tort can't incidentally award compensation for impact on reputation. But what the tort should not do is make something private because of its reputationally damaging impact.
If there is a claim for damages for impact on reputation, why is it, and it's a fundamental question, and the answer may be very obvious and I might have missed it, why is it that you can't then prove that they're not deserving of that award because they have a bad reputation, because the allegation is true?
Because it's been held structurally that the truth of the private information is irrelevant in the tort of
the cause of action.
To the cause of action.
But not to the assessment of damages. But why does it have no impact on the assessment of damages? You say you're prohibited from establishing that it's true, but if somebody's unwise enough to say, oh, well, I have a reputation that's been damaged in a misuse of private information case, why can't you then establish they're not entitled to those damages?
Well, Mr. Justice Warby's answer to that in SICRI, which I'm coming to next,
Yes.
is it's inappropriate to import into the developing tort of misuse of private information the statutory and other apparatus which exists in the tort of defamation, in relation to which that inquiry will take place. So SICRI is the next and important case in this line of argument. There was in SICRI no concession that the underlying facts were false. So the second reason given by Mr. Justice Nicklin at first instance in the present case wasn't present. SICRI is the case of a man named in the newspapers after he had been arrested in the aftermath of the Manchester Arena bombing. And it turned out that he was entirely innocent. He had received a telephone call from Mr. Abedi, I think it was, who was the bomber, because he ran a business which included, amongst other things, foreign exchange between England and Libya. And Mr. Abedi had rung him in that context, and that's why the police arrested him. But once that link had been explored, he was released without charge. But he recovered damages for misuse of private information in publishing the fact of his arrest. Sorry, I have the wrong bundle open, please forgive me. But although he recovered damages for misuse of private information, Mr. Justice Warby, following Mr. Justice Nicklin in the present case, held that he could not recover any damages for injury to reputation. There's a lengthy explanation of that at paragraphs 154 to 158, pages electronic 1549 to 1551. Perhaps the kernel of it appears between 154 and 156. He says, neither Richard nor any other authority, well, this is page 1549, I'm not sure I said that, page 1549 electronic. Neither Richard nor any other authority holds that an individual can recover in a misuse claim, misuse of private information, he means, damages for reputational injury caused by the publication of information that is defamatory but substantially true. The common law has prohibited this for centuries, and in 2013, Parliament put that prohibition on a statutory footing via Section 2 of the Defamation Act 2013. Well, that's recasting the common law defence of justification as the defence of truth. If the claim is brought in defamation, I see no principal justification for allowing any such claim to be maintained in the newly discovered tort of misuse of private information. The facts that the information is private and that its publication represents a misuse of the information don't appear to me to be relevant or sufficient reasons for doing so, nor does the fact that the rationale for protecting the information is the reputational harm that disclosure might cause. And then he addresses a submission by Mr. Tomlinson that if protection of reputation was the basis for the general rule in the Court of Appeal in the present case, then damages for reputational harm ought to be recoverable. But he moves on to, at 156, to this. He says, the example I raised in the course of argument was an obvious one. What of the terror suspect whose identity as such is wrongfully disclosed in breach of his privacy rights, but who's later charged and rightly convicted? Would surely be offensive to long-cherished notions of justice to award him compensation on the footing that all the reputational harm caused by disclosure between arrest and charge was unwarranted. That could not happen if the claim was brought in defamation. I do not believe it should happen in misuse of private information. In order to avoid that result, it would be necessary, so it seems to me, to import the relevant legal principles from defamation, That would be a cumbersome process. One may ask, why should it be regarded as necessary in a democratic society to do this, or more generally, to interfere with freedom of speech affording a remedy for reputational harm by means of this emergent tort when another mature tort is available for the purpose? It seems hard to answer this question. When Parliament so recently legislated in this field, it becomes harder. And so he holds, consistently with Mr. Justice Nicklin in the present case, that there can be no award of damages for injury to reputation in the tort of misuse of private information.
So what do you award damages for?
You award it for non-reputational impact, undermining of personal integrity, distress, but you can't award it for injury to reputation. And, my Lord, the respondent to this appeal accepts that those two cases are rightly decided on the question of damages. But in our submission, they throw up a point of real significance, which is this. If the claim posited by Mr. Justice Warby in paragraph 156 were brought in defamation, there would not just be no award of damages for injury to reputation, there'd be no liability at all.
Well, I mean, the difficulty is that whatever may be agreed between the parties, this is the first case on this tort to reach this level in a very long time, and there's been well, there have been a lot of decisions by first instance courts, particularly, such as the one we're looking at here. And we can't. I mean, this is an opportunity for this court to try to give some guidance.
Oh, I quite agree, my Lord. I wasn't.
What occurs to me is that the whole rationale of developing this tort is to fill a lacuna that essentially the existing torts, including the tort of defamation, didn't meet the requirements of Article 8. And so this tort has been developed in order to meet that need. And it seems rather perverse if the tort then doesn't provide the remedy which Article 8 would call for.
But, my Lord, I submit that my Lord puts his finger on it, that the emergent tort was to fill a gap. There isn't a gap. The law of defamation allows...
But the law of defamation doesn't enable you to recover damages for the publication of true information.
And in our submission, rightly so.
But that's an Anglo way of looking at things. The European approach to privacy. I mean, the whole point is it's not defamation we're dealing with; it's privacy, and your privacy can be invaded by the publication of true information.
If it's private,
yeah,
but not just because it's reputationally damaging. My Lord, this is a big point. I don't suggest you're held by the consensus between the parties, but I do, as strongly as I can, urge that the reasoning in SICRI is compelling, but it stops short of its true conclusion, which is a claim of this kind, based on damage to reputation, should be left to the mature and natural tort, with its defences, which are different to those available in misuse of private information, and it's not appropriate to develop the emergent tort in a way which is inconsistent with the law of defamation.
But the difficulty I have is that the whole rationale of this tort is to address a legal need that isn't met by the tort of defamation. And in order to comply essentially with convention requirements. And in deciding what the various aspects are of that tort, it's essentially illogical to be guided by the need to avoid an inconsistency with the tort of defamation, which ex hypothesi is unsatisfactory for the purpose.
Well, I make with trepidation the contrary submission, that if you're filling a gap, it's very important to look what's already there and gives a remedy for untrue but reputationally, that doesn't give a reputation for untrue, but reputationally damaging information. And Mr. Justice Warby is, in our submission, onto an important point when he talks of the maturity of the tort and its inbuilt features and the way in which it shouldn't be imported on the basis of harm to reputation. What we submit the emergent tort was intended to deal with was largely true private information that wasn't reputationally damaging. So medical information. People don't think any the worse for you if you've gone into hospital for an operation. That was what was previously outside the reach of the law. And the cases like Kay and Robinson about the newspaper interview that took place in hospital were about that lacuna. But there isn't a lacuna in the law in relation to the protection of reputation. This claimant could have sued in defamation. On our analysis, he would have been in difficulties because we could have pleaded reasonable grounds to suspect and relied on what we now know is the true fact of his providing false information to the board. But the fact that there's a defence in the mature and natural tort can't drive the development of the emergent tort in our submission. My Lord has our point. And my Lord, I just...
So, for example, if one imagines a female television star and a newspaper publishes the information that she's recently been treated for a sexually transmitted disease, and that information is true, she cannot recover damages for the impact on her reputation.
No, that's not the way I put it, because she would be able to bring a misuse of private information claim because that information is clearly private. And it would incidentally protect, I use Professor Moram's expression.
And what would one be awarding damages for if it's not, apart from, I think you're agreeing with me that she wouldn't be able to recover damages for the effect on her reputation.
Well, my Lord, I don't need to put it that high, because where it's private information which sometimes does impact on reputation, then the claim can lie. What our objection is to the claim lying in privacy because the information's reputationally damaging, not because it's private. And my Lord, the point I've been addressing so far is dealt within the authorities from the position of the available...
I'm so sorry, but the way you've just put it there seems not to be consistent with what Mr. Justice Warby was saying. Because in the answer you just gave, you said there could be relief in relation to harm to reputation, just so long as you had a proper cause of action in misuse of private information. But I thought that the point Mr. Justice Warby was making was, well, even if you've got a misuse of private information, you can't have a remedy in relation to reputation.
Lord, I may have agreed too readily. It's certainly the case that where the information is not of itself private, but is only said to be private because of its impact on reputation, then you can't use this emergent tort in a situation where you couldn't use defamation.
So you can get damages for reputation in a reasons-based approach, but not in a consequences-based approach, and using the Denisov criteria.
Well, that may be.
That's fairly complicated.
Well, Lord, I don't pretend it's easy. I find this a very difficult case, and Mr. Justice Warby's distinction ruling out damages for injury to reputation because of the interrelationship between the two causes of action, but ruling in liability, in our submission, the reasoning is compelling, but it drives one further than he felt driven. But I'm conscious of my allocation of time, and it's the most interesting discussion. No, the last thing I want to do is appear to be dodging questions. My Lord, the last point to make on this is the reasoning I've drawn particular attention to is driven by the lack of availability of a truth defence in misuse of private information. But it's not limited to that, and that's the further point that Mr. Justice Warby makes. There are other special features of the law of defamation which should not be outflanked by casting a claim in misuse of private information. And an obvious one of those, which was present in SICRI, is the 1-year limitation period. Defamation has a uniquely short 1-year defamation period compared with other torts. And if you allow a claim for injury to reputation in a case where the information is not part of the sphere of private life to proceed because it's damaging to reputation, you risk outflanking the 1-year limitation period which Parliament has thought it appropriate to introduce. And there are other defences codified in the 2013 Act as opinion, public interest, which all have their special features and apparatus, which it's inappropriate to import into the emergent tort. My Lord, Mr. Justice Warby puts it far better than I can. He says it is principle underlined practicality. My Lord, there's just one other point. I fear I've now said my next last point, but there's one other point on ground one, which is this. This is not a field without legislative intervention. The 2011 Education Act inserted into the Education Act 2002, Section 141F, which we have at page 4614. That provides for pre-charge anonymity for teachers accused of criminal offences by pupils at their schools. But there is no wider legislative provision for pre-charge anonymity. Now, I'm conscious of the fact that you can't extract Parliament's intention by what it hasn't said. I've run up against that before, but there is nevertheless a point mentioned in authorities at the highest level as to whether a field is one which has received parliamentary intervention. Where it has, and it is limited, that is a reason for judicial caution in introducing a general rule like the Court of Appeal has done, which is prima facie pre-charge anonymity.
What was the reference, Mr. White, to the Education Act?
I'm sorry, my Lord, the reference to Section 141F is page 4614.
4614. Thank you very much.
Thank you. Lord, in the half hour, in the 20 minutes I have left, just under 20 minutes I have left, I need to deal with ground two of the appeal, and it raises important issues about the interrelationship between this emergent tort and the law of confidence, which gave birth to it. Although a claim for breach of confidence was pleaded in this case, it wasn't pursued at trial, and it was dismissed by Mr. Justice Nicklin. And my Lord, for all the, with all the references we've given in our case, and I'm not going to and don't have time to set out seriatim now, it is clear from reading the judgment of Mr. Justice Nicklin at first instance that he attached great significance to the confidentiality of the letter of request and the public interest in maintaining the confidentiality of the UKLEB's investigations at both stage one of the analysis, reasonable expectation of privacy, and at stage two, the Article 810 balance. And we set out all of the references at paragraphs 83 to 84 of our case. The Court of Appeal upheld both aspects of the judge's judgment and dismissed our attack on the judgment, alleging that the judge had conflated private information with confidential information. Lord, on this ground, we make two main submissions. The first is that the judge's reasoning upheld by the Court of Appeal contains an impermissible jump from confidentiality to privacy. The second is that the confidentiality of the letter of request didn't undermine the public interest in reporting information drawn from it. Dealing first with the jump from confidentiality to privacy, it is axiomatic that the fact that information is contained in a confidential document doesn't make it private information. To be private information, it has to relate to activities within the sphere of private life, to use Lord Rogers' expression in Countryside Alliance. And can I just show you a similar formulation in Lord Nichols in Naomi Campbell, the case that gave us the emergent tort. Lord, at page 954 in Naomi Campbell, paragraph 20, immediately before Lord Nichols posits the reasonable expectation of privacy test, which has been so influential, he says at the end of 20, after referring to both limbs of Article 8, this question, that's the balancing of rights under Article 8.2, is distinct from the initial question of whether the published information engaged Article 8 at all by being within the sphere of the complainant's private or family life. And the short point we submit is that just because information is contained in a confidential document doesn't mean it falls within the sphere of private life. And as we explained under ground one, the activities of the respondent referred to in the letter of request were not within that sphere. They were his activities as the chief executive officer of a division of a public company. They weren't activities within his private life. And my Lord, we say it's important to recognize that on the developing state of the law in relation to this emergent tort, breach of confidence and misuse of private information are two different causes of action, and they protect different interests. It's well known that the cause of action or tort of misuse of private information was developed from or out of breach of confidence. And for some years after the Naomi Campbell case, it was unclear whether there was one cause of action, breach of confidence expanded to protect privacy, or two. But that point arose for decision in a case called Vidal Hall and Google. It arose because at that stage there was no gateway for service out in a breach of confidence case. And so to bring a claim against Google for breach of confidence or misuse of private information when there was no statutory gateway for service out for those torts, expressly for those causes of action, required the court to consider whether misuse of private information could pass through the tort gateway. And so in Vidal Hall, at paragraphs 21 and then 24 to 5, that question was answered by the Court of Appeal, and they held that although breach of confidence is not a tort and had no gateway for service out at the time, misuse of private information is a tort. And can I show you, it's firstly page 2969, paragraph 21 of Vidal Hall. The submission for Google had been that because of its equitable origins, misuse of private information remained in the confidentiality genus. I think that was an expression used by Lord Neuberger. And therefore you couldn't use the tort gateway for service out. But starting at 21, that argument's rejected by the Court of Appeal. They say, There are a number of things need to be said. First, there are problems within analysis which fails to distinguish between a breach of confidentiality and an infringement of privacy rights protected by Article 8, not least because the concepts of confidence and privacy are not the same and protect different interests. And then, my Lord, can I ask you to jump forward to paragraphs 24 and 25 at page 2971. There's a quote from Lord Nichols in Douglas and Hello number 3, where he said, as the law has developed, breach of confidence or misuse of confidential information now covers two distinct causes of action, protecting two different interests, privacy and secret or confidential information. It's important to keep those two distinct. In some instances, information may qualify for protection both on the grounds of privacy and confidentiality. In other instances, information may be in the public domain and not qualify for protection as confidential, and yet qualify for protection on the grounds of privacy. Privacy can be invaded by further publication of information or photographs already disclosed to the public. Conversely and obviously, a trade secret may be protected as confidential information, even though no question of personal privacy is involved. And the Court of Appeal observed in paragraph 25 that those remarks are obviously correct. Actions for breach of confidence and actions for misuse of private information rest on different legal foundations. As Lord Nichols said, they protect different interests, secret or confidential information on the one hand, and privacy on the other. And then the summary of the development in Campbell, as set out at the rest of paragraph 25, uses the expression, the right to control dissemination of information about one's private life.
Well, yeah, and read on, and the right to esteem and respect for other people. I mean, I don't want to go back over the debate we had about reputation, but those look like reputational interests, don't they? The right to esteem and respect of other people.
Well, but my Lord, in the context, as I showed you Lord Nichols' initial question, in the context of information which falls within the sphere of private life, many things affect esteem and reputation which aren't private. Being charged affects your esteem and reputation, but there's no suggestion that's part of your private life. It's expressly accepted it's not. But, my Lord, the distinction matters in the present case because if the information about the respondent's activities contained in the letter of request wasn't information about his private life, we submit that the confidentiality of that document and the public interest in maintaining the confidentiality of the UKLEB's investigations could neither create nor reinforce a reasonable expectation of privacy. The mistake is treating as private non-private information which appears in a confidential document. And, my Lord, it might give rise, the fact that it's drawn from a confidential document, to an expectation that it wouldn't be made public, but that's a different matter. That would apply equally to the trade secret. But as Lord Nichols explains, the trade secret isn't private information. And one can test it in this way in our submission. If instead of referring to the respondent's activities as the chief executive officer of a division of a public company, the letter of the LOR had referred to and set out a trade secret that he'd developed, the confidentiality of the document might have given him an expectation that his trade secret wouldn't be made public, but it couldn't make the trade secret his private information. It wouldn't have that effect. And, my Lord, that highlights what we submit is an important point about the reasonable expectation of privacy test. It has two components. One is the reasonableness of the expectation, but the other is privacy. And some factors may go to a reasonableness of an expectation, my example about the trade secret not being made public, without supporting the private nature of the information in question. And, my Lord, we've set out further authorities at paragraphs 91 to 94 of our case, where it's been recognised that not all information communicated in confidence or contained in a confidential document is necessarily private. And I'm not going to repeat all those authorities, not least because I don't have time. Perhaps the closest case in the books to the present is Axon and the MOD, which I mentioned this morning, where it was held that even though information about the MOD's assessment of the claimant's bullying behaviour was set out in documents which were actually marked confidential, and the purpose of the confidentiality was to protect his reputation as an investigated person, nevertheless, because the conduct in question was not within the sphere of his private life, the claimant had no reasonable expectation of privacy. And therefore, the claim based on misuse of private information failed. Well, the second point, I'm sorry, I'm slightly cantering, but I need to meet my 3:30 deadline. The confidentiality of the letter of request did not, in our submission, undermine the public interest in reporting information drawn from it. We've seen that the judge, without hesitation, accepted that the issue of corruption in the foreign state and possible involvement in that corruption by X Limited and its officers was a matter of high public interest. But he disregarded or downplayed that high public interest because the article wasn't presenting the fruits of an investigation by Bloomberg, but was information drawn from the letter of request. And that's a distinction he repeats twice in the judgment. In our submission, it's another unsatisfactory distinction. Drawing information from a confidential document is, which a journalist is either shown or given, is in our submission an obvious kind of journalistic investigation or inquiry. That there's no principled basis for saying that a journalist who obtains information from a number of human sources and puts the pieces together is engaged in journalistic inquiry or investigation, whereas a journalist who looks at a confidential leaked document and gets information from it is not. And my Lord, we submit that the distinction is not just unsatisfactory, it's inconsistent with the decision of the Strasbourg court in Fressars and Roy against France. My Lord, the relevant passages are at page 4084 to 4085. What had happened in that case was that the applicants to the Strasbourg court, who published a satirical magazine, had received a document in breach of confidence from a tax official. That document showed the remuneration and pay increases of the chairman of a public company. At the time, the company, I think it was one of the French car manufacturers, was resisting demands for pay increases from its employees. And the article in the satirical magazine contrasted the level of pay increase of the chairman with the unmet demands of the workforce. And the Strasbourg court held that the applicants' Article 10 rights were violated by their convictions for publishing the document they'd received in breach of confidence. And Lord, the reasoning involves this step. The information contained in the document was held to contribute to a debate of general interest. One sees that at paragraph 50. And it could have been discovered, that information, from official records by other journalistic inquiries. The reasoning of the Strasbourg court on which we rely essentially recognizes that once the information, the publication of the information was in the public interest, it contributed to a debate of general interest, Article 10 allowed the publisher to take it from the confidential document received in breach of confidence, even though they could have got it from other journalistic inquiries. Now, my Lord, one can test the point I'm making in this way in my submission. If one imagines a situation in which two newspapers publish articles on the same day about the same issue, the first one having discovered the information from human sources and the second from a leaked confidential document. The question whether the articles published by the two newspapers were in the public interest should, in my submission, receive the same answer, because they depend on the information published, not the method of journalistic inquiry. And we point out in our case that one reason for that ought to be that the test applied by the Court of Appeal in a case called Ali and Aslam against Channel 5 Broadcasting, I'll just give you the page references, 381728 and 3819 to 20. The test applied for whether particular information could be included in that case, a broadcast on a matter of public interest, depended upon a rational connection between the information and the issue of public interest. That's described as the crucial principle at paragraphs 83 and 92. But in our submission, the rationality of the connection wouldn't be affected by whether the information had been obtained from human sources or from a leaked confidential document. May I close with one further short point which falls within ground two, which is in our case, but just to make sure I bring it to your attention. We submit the judge's focus on confidentiality led him to apply the wrong test at the balancing exercise. There are two tests in the Prince of Wales case in the Court of Appeal in paragraphs 65, contrast paragraph 68 of the Master of the Rolls judgment in that case. Well, that's pages in the bundle 1061 to 2. The judge applies the test which relates to information communicated in confidence, which requires a public interest outweighing the public interest in the preservation of confidence, rather than the test which applies where there is no communication in confidence, which just balances the privacy right against the Article 10 right. And my Lord, we submit that the focus on confidentiality leads him to that additional error. My Lord, for all those reasons, we submit that the appeal should be allowed in relation to grounds 1 and or 2. And just on ground 3, I should just say, we don't suggest that you should redo the balancing exercise unless there's a mistake made of the sort which I've been urging upon you. My friends are, of course, right to say that the court doesn't redo the balancing just because it is concerned about the outcome. But we say there are the errors I've drawn attention to.
Thank you very much indeed, Mr. White. Mr. Owen.
My Lords, in responding to Mr. White, I intend to address you under 5 headings. In part 1, I'll summarise why we say that Bloomberg's arguments on issues 1 and 2 are based on what we do with respect, say, is a fundamental distortion or misstatement of the reasoning of both Mr. Justice Nickling and the Court of Appeal. In part 2, and specifically focusing on issue 1, we'll examine in greater detail what Professor Phillipson and Mr. Craig, in their recent article, which the court has had in the last few days, in what they call the developing consensus concerning the privacy rights of suspects in criminal investigations, with a view to demonstrating, by reference to the Campbell-Murray framework, the stage 1 question of the reasonable expectation of privacy, that this area is now a conventional, widely accepted category of information that, to use the language of the test, reasonable people of ordinary sensibilities in the position of the claimant usually regard as private, but subject always to the balancing exercise against the Article 10 right to freedom of expression. In other words, we say there is nothing novel, radical, or surprising in the judgments of the courts below. On the contrary, we say the decision to find that Article 8 was engaged on the facts of this case reflects the decision taken as long ago as 2009 by the House of Lords in the BBC case, I'll show it to you perhaps tomorrow, but just for your reference. The case is at E2538, electronic bundle 2538, and see in particular Lord Hope's speech, paragraph 22, page 2557. So the decision to find engagement was reflected in Lord Hope's speech in BBC, as well as the broad, flexible concept of the Article 8 right, as explained by Lord Sumption in the 2015 decision in this court in CAT. Again, I'll just give you the reference for now. It's E1225, electronic bundle 1225. It's paragraphs 3 to 4 of Lord Sumption's judgment. Those are two authorities that my learned friend has not taken you to, but they are in my submission crucial to understanding how this stage 1 test is to be answered. And as Mr. Justice Warby, as he then was, said in Sikri at paragraph 76, quote, "The notion that information about official suspicion engages an individual's Article 8 rights because of its reputational impact appears to me to have been firmly established at the highest level over a decade ago." And there, Mr. Justice Warby was referring to the BBC case in 2009. In part 3, I will address you on what I suggest is the 5-pronged attack made by Bloomberg on the lower court's rulings in this case. And the 5 prongs are the presumption of innocence issue, the reputational damage issue, the respondent's status issue, the artificial distinction issue, and the outflanking of defamation issue. In part 4, and parts 4 and 5 will be reasonably brief, but in part 4, I'll deal with the second issue and argue that the lower courts did not make the elementary error of wrongly conflating confidential information with private information. And I'll seek to explain why the highly confidential and sensitive nature of the information published by Bloomberg was rightly regarded as the most significant factor, both at stage 1 and at stage 2, when conducting the balancing exercise between Article 8 and Article 10. Fifthly and finally, I will very briefly seek to demonstrate that if, as we argue, the lower courts reached the right conclusion about the engagement of Article 8 by the fact of the publication of the information in issue, then with respect, Bloomberg's appeal is hopeless, given the concurrent factual findings made in the courts below. Our position, in short, is that this appeal is really about whether the lower courts were right to conclude that the decision to publish the contents of the leaked letter of request engaged Article 8, right to privacy. That is really what the meat of this case is about, and my learned friend has focused on that, I would respectfully suggest, and developed the rather elaborate dissection of the courts below approach, because once it is accepted, as we submit it must be, that Article 8 is engaged by the decision to publish, then the submission that the courts below got the balance wrong is an impossible one to sustain at this level. But before I set out our submissions under the 5 headings, can I make what we say is an important preliminary point, namely that in finding for ZXC, the lower courts could hardly be said to have been breaking new ground or marking a radical departure from existing legal principles. Again, going back to what Mr. Justice Warby said in Sikri, and again for your note, it's paragraph 61 at page 1526. He said the legal framework, meaning confidentiality of suspects in the Moppy tort. The legal framework is, quote, well known and uncontroversial. And the key principles of law applicable to this case were never in dispute below. As Lord Justice Simon observed, many of the principles were largely agreed at the hearing of this appeal as they had been before the judge. And Mr. Justice Nicklin said there is a large degree of agreement as to the legal principles to be applied. And that is expressly acknowledged in the agreed statement of facts and issues, paragraph 16, electronic bundle 66. It's common ground that liability for the misuse of private information tort is determined by applying this two-stage assessment. See what Lord Justice Buxton said in McKenna and Ash. And the first stage is an objective assessment of what a reasonable person of ordinary sensibilities would feel if she or he were placed in the same position as the claimant and faced with the same publicity. That is an objective assessment. That it is an objective assessment is plainly important. Private information, we accept, is not all information which a claimant may wish to keep to him or herself. An action based solely on that criterion would leave freedom of expression at the mercy of neurotic, controlling, or oversensitive individuals. A claimant must be able to establish under the test a reasonable person of ordinary sensibilities in the claimant's position would expect privacy protection in relation to the information. And the answer to the stage one question is based on all the circumstances. We accept that, of course, including the factors set out by the Court of Appeal in Murray. See Sir Anthony Clark, as he then was, paragraphs 35 to 36. And against that background, and despite my learned friends' dense printed case bristling with defamation case law, we do say with respect that this was and remains a fact-sensitive case with no fundamental dispute about the questions which must be resolved in a misuse of private information claim. There's nothing unusual about this. Indeed, in Murray, the Court of Appeal emphasised, and perhaps if the court would just go to E17 in a different passage from Murray, at paragraph 41. No, that's not right. That's a BBC case. What's the reference to Murray?
It is treble one.
It is correct.
It is, is it? Oh, yes, sorry. Yeah. Paragraph 41. At each stage, Sir Anthony said, the questions to be determined are essentially questions of fact. The question whether there was a reasonable expectation of privacy is a question of fact. If there was, the next question involves determining the relevant factors and balancing them. Baroness Hale put it in Campbell at 157, the weight to be attached to the various considerations is a matter of fact and degree. That is essentially a matter for the trial judge. And for all of the complex arguments advanced by Bloomberg, we don't understand them to dispute that the question of whether a reasonable expectation of privacy exists is in essence a factual question to be decided on the basis of the evidence before the first instance court and having regard to all the circumstances. True it is that this may be, well, it is the first occasion on which a case which directly concerns the privacy rights of a suspect prior to a charging decision is before this court. But there was already ample authority at this level, which meant that the task of the lower courts in considering the engagement of Article 8 within the well-established Campbell, Murray framework governing the tort was a relatively simple one. And before this court, and with great respect to my own friend, Bloomberg seemed to be determined to complicate what remains a fairly straightforward exercise of analysing the precise facts of a given case within a simple legal two-stage exercise, which is always highly fact-sensitive, and to do that while issuing dark warnings of the destruction of the media's ability to expose wrongdoing. See what my learned friend says at paragraph 11 of his case at E85. He says, if allowed to stand, the Court of Appeal's decision will have anomalous and unwarranted consequences for the development of the misuse of private information tort and its interplay with defamation, as well as for freedom of expression. And we respectfully disagree with that proposition. Bearing in mind what Lord Sumption said in Cat about the elastic nature of the Article 8 right, perhaps we can just look at that now. It's at E1225 at page 3, paragraph 3. Just to remind the court, the case concerned whether or not the recording of information about Mr. Cat, about his public activities in form of attending political protests, whether the recording by the police as a result of surveillance operations of him in the public domain and then putting that information on a database called the Domestic Extremism Database, which was never revealed publicly. No one knew it existed, and he, Mr. Cat, only discovered it existed by a side wind. The question was whether, firstly, Article 8 was engaged by the maintaining or the recording of the information, and if it was, whether it was justified. And at paragraph 3, perhaps if I invite the court to read paragraphs 3 and 4, which are quite long, but they're both important.
Yeah.
So what one sees from paragraph 3 and the quote from the case of Pretty against the United Kingdom, an echo of the point that my Lord Sales was raising in relation to the Nimitz case, and it's a repetition of what Article 8 is protecting, the right to establish and develop relationships with other human beings in the outside world, and the reference to the concept or the notion of personal autonomy is an important principle underlying the interpretation of its guarantees. And going back to my Lord Reed referred to to an Anglo lawyer, the Article 8 concept of privacy as used terminology which isn't perhaps natural for an English common lawyer. That concept of personal autonomy here is all about keeping control of information, keeping it private in the context of its capacity to affect your right to establish, develop relationships with other humans in the outside world. Therefore, the release of it or the loss of the control of it has the capacity to cause the kind of harm which Article 8 seeks to guard against. And here, if you ask the question, I submit, which is quite a useful one, of saying, is this information that's published by Bloomberg private or public? The answer is it's obviously private. It's contained in a secret or confidential, highly sensitive letter of request setting out the suspicions and beliefs of a law enforcement body at an early stage about the conduct of ZXC. Is it, and this is a binary question when one is looking at this stage, you ask yourself, well, it's either private or it's public, in effect, for the purposes of this issue. And if you start with the source of this information, which ends up printed by Bloomberg, in my submission, it screams out that it's private information. Whether it's justified to publish it is a quite separate issue. But if, as is the case from CAT, the recording by the state of Mr. Cat's public protest activities and putting that information into a database with a particular label on it, I accept a somewhat controversial labeling of him as a domestic extremist. It's not conviction data, it's observational data based on surveillance at these various demonstrations where violence took place, but not by him. I think he was 97 at the time when he was attending these demonstrations, but they were recording the information nonetheless. Now, if the recording of his public activities in a systematic way on a database engages Article 8, then I ask rhetorically, how can it possibly be argued that the recording by the UK LEB in this case of its information that it has gathered about ZXC and the beliefs or suspicions that it has formed about him, how can it really be argued in light of CAT that that doesn't engage Article 8 at all? So there's no question of justification. In my submission, it's an impossible task, and I do rely very heavily on those paragraphs from CAT. The court went on to hold, with Lord Toulson dissenting, that the database was justified. There was a legitimate policing purpose behind the recording of the information because of the violence that had taken place at this one particular demonstration that he regularly attended, which was about an arms factory in Brighton. But that was all at the second stage. At the first stage, which is really what my learned friend has to win on in this case, and it's why he spent so much time trying to unpick what I say is the factual answer given by the lower courts, is because once it's accepted that the courts were right to say that Article 8 is engaged, it's then an impossible task in my submission to say that somehow the courts got the balancing exercise wrong. Certainly impossible at this level. This case, as I say, involves the publication to the entire world of leaked, sensitive, confidential information from the formal letter of request. It's agreed, see the statement of facts and issues at paragraph 3, Roman 1, E, electronic bundle, page 61, or it could be 3I on page electronic 61. It's agreed that the information in the Bloomberg article about ZXC was almost exclusively drawn from the letter of request. And the judge found as a fact that none of the facts relating to the scope of the investigation or the matters in respect of which the UK LEB suspected him had been made public by the UK LEB. And that is made clear in paragraph 3F of the SFI, the Statement of Facts and Issues, electronic bundle 60. And if you want to look at the press releases, or for your note, the press releases that the UK LEB had issued since first commencing its investigation many years ago, almost, I think, 9 years ago, that's at electronic bundle 730 to 738. There are 7 of them. They are all a couple of lines long, and none of them make any reference to ZXC. The article itself, and the article for your note is at Electronic Bundle 660, actually boasted that it was publishing private information or non-public information. I won't read out the quotes from the article because it could enable jigsaw identification, but we quote those 2 sentences from the article in the confidential schedule to the particulars of claim at paragraph 610 E392.
Can I just raise this, Mr. Owen? If one's trying to put one's finger on a touchstone,
Yes.
Asking whether the information is private or public may not always be perhaps the most helpful way of posing the question, it seems to me. I mean, obviously, any information which hasn't entered the public domain previously might be regarded as private.
Yes.
If that's the distinction being
Yes.
drawn. And as I indicated indicated this morning, I've some hesitation about the reasonable expectation of privacy test as being sufficient in itself, because it isn't easy applying that form of words to distinguish between the drug dealer who is observed carrying a bag along the street,
Yes.
and J.K. Rowling being observed pushing her pram down the street.
Yeah.
When you look at the Strasbourg cases, I don't remember the exact form of words they've used, but they are, I think, asking whether the information in question falls within the scope of the right to respect for private life.
Yes.
And really, the answer to that would depend on how its publication would impinge on the aspects, the personal interests which are protected by Article 8.
Yes.
Personal autonomy, personal integrity, social relationships,
Yes.
family relationships, and so forth. And although
Yes.
it's not such a nutshell definition, it may perhaps be a more accurate one.
Oh, yes. My Lord, I accept, in saying the binary point, I was looking at the source of this particular information. Yeah. Is this information, which is the basis of the claim, is it public information?
Yes.
To which the answer is, it isn't. Now, that's a sorry.
Yeah, but your client's complaint isn't that this was private in the sense that it hadn't previously been published.
No.
His complaint is it triggers his right to respect for private life because its publication would impinge deleteriously upon the personal interests which are protected by Article 8.
Yes, well, with respect, absolutely. The point I was simply making is that the nature of the information, its source, whether it was in the public domain or not, is a relevant factor to the Article 8 Stage 1 test.
Yes.
Reasonable expectation of privacy test. But yes, except entirely what my Lord says, and that's really what Lord Sumption is describing in paragraphs 3 and 4 of CAT.
Yeah, yes, I think so.
As being necessary factors to take into account. And so against that background, we say that the proposition that the act of publishing this sensitive and highly confidential information about ZXC doesn't engage his Article 8 right to privacy at all, and thus requires no justification for its publication, is an impossible argument to sustain. In her 2019 article, Privacy, Reputation and Alleged Wrongdoing, why police investigations should not be regarded as private. That's E 1806. Professor Moram, upon whom great reliance has been placed by the appellant, she argues in the section, should evidence of wrongdoing be private, that privacy protection is usually given to matters which belong to the intimate spheres of life, those which relate, for example, to intimate relationships, sexual expression, domestic and family life, or the appearance of the workings of the physical body. She concedes that, quote, a police investigation itself might stray into this territory, but it's not clear that the fact that the investigation is taking place or details of how it's being conducted belong to these intimate spheres of life. That's E 1820. With great respect to Professor Moram, it would seem that she hasn't fully grasped the factual situation in CAT, which led the Supreme Court, without really any difficulty, to conclude that Article 8 was engaged by the facts of that case. As I've said, 3 and 4 we've looked at, but in paragraphs 5 to 6, he summarized the Strasbourg case law, looking at Rotaru, BB, and France, before holding that it's clear that the state's systemic collection and storage in retrievable form, even of public information about an individual, is an interference with private life. And I've made that point.
Well, the way she puts it is that, well, she says it will typically be the case if the information relates to matters such as health, intimate relationships, domestic and family life, and so forth.
Yeah.
And as I understand, the way you're putting it is really to say, well, it's sufficient if it impinges in a material way upon these various, intimacies of relationships. If it's going to impinge on personal relationships, family life, and so forth.
Yes, precisely.
And it doesn't have to necessarily relate to those topics in order to have a detrimental impact upon them.
Yeah. I'll be making the point now tomorrow when I come to part 2, which simply looks at the consensus, the public policy, and the case law, that this is a category of information, i.e. you are a suspected by a state body of a criminal offence, pre-charge. That is a body of information which is now pretty universally regarded as private. I'll come on to the general rule and why it was never a general rule in the sense of a rigid rule. It was no more than a starting point.
I follow the way that you're putting your case in answer to my lord. I'm not sure CAT helps you terribly much on that, because that was dealing with what I understand to be quite a well-recognised category of case in Strasbourg, where basically the police have databases which they can refer to whenever they like in the future. And it's if you like, the state maintaining data in that way for reference by itself that constitutes the breach of Article 8, whereas we're dealing with a different situation. True, there's a state investigation in the background, but it's the use that information about that investigation has been made by Bloomberg, which is what we're concerned about, which seems a different sort of situation.
Well, my lord, yes, but if the horizontal effect principle applies, this court is looking, the starting point is it the quality, does it have the quality that engages Article 8? And the mere fact that this is a case involving a media company rather than a state body as in CAT, in my submission, doesn't alter the principle about whether this is the type of information in its original form gathered by the UKLEB, the recording of information about an individual on the basis they suspect him of criminal activity, and the recording of it and putting it in the letter of request. There isn't, although I accept what my lord says, that in paragraphs 5 and 6, Lord Sumption looks at that body of Strasbourg case law, which has looked at databases and systemic collection of intelligence material and so on. But as a matter of principle in my submission, it's hardly surprising that the lower courts formed the view that the recording of information about a suspect in a formal way, and putting it in the letter of request, it requires justification, whoever releases it, whether it's a state body or the media who get it, in this case, no doubt as a result of the commission of a criminal offence by whoever gave it to Bloomberg.
Just wondering whether the Denisov approach at page 1738, which breaks down the engagement of Article 8 into a reason-based approach at paragraph 103,
Yeah.
And a consequence-based approach at paragraph 107.
Yeah.
That doesn't find any reflection, as I understand it, in the Murray test.
Well, no.
But it seems to be the test used by the European Court of Human Rights for the engagement of Article 8.
Yes, I would say that the approach, as I've said in my introduction, the questions are not difficult, the framework isn't difficult, and the requirement is to take account always of the circumstances of every case. And Murray simply provides a list of some of the most obvious relevant factors.
Well, is that a convenient
Yes, it is.
moment, Mr. Very well,
I'll
then.
be starting then on section part 1 and tomorrow.
Thank you. Well, in that case, we'll adjourn now, and we'll resume at 10:30 tomorrow morning.